Okay, we'll call the hearing back to order. I noticed a few people had made comment that they thought it was cold in here, and I didn't notice. I thought a lot of y'all were getting sort of red in the face, so I thought it was warm. Anyway, we have tried to adjust the temperature, and hopefully everybody will be more comfy. Mr. Richardson.
Thank you very much, Mr. Chairman. Mr. Winnick, you knew this project was being financed by the customers paying $1 billion by the time Bechtel did its assessment and when it was finalized, don't you?
I knew that the fee for Bechtel services was $1 million, yes.
Yeah, but you also knew that the project was being financed by charges to ratepayers. And $1 billion have been charged to ratepayers at the time that the Bechtel assessment was occurred. I
didn't keep track of that number. I certainly knew that in a regulatory environment, the 55% owned by SC DN was being paid for by ratepayers according to this commission's orders. Yes.
And did you know that they've paid another $1 billion since the Bechtel assessment?
No, there was no reason for me to keep track of that number, and I didn't.
But you know why we're here today, that we're here trying to figure out how much more of the $5 billion that was spent on this project by SC&G is going to be charged to customers now that it's collapsed under the weight of the schedule and the budget.
I know that rate issues are one of the matters before the commission right now, yes.
Do you feel any responsibility at all?
No. I think Westinghouse and their decision to file bankruptcy bears the entire responsibility for the mess that they left the parties, the owners, the ratepayers, everybody in.
All of it?
100%.
Is that because you're getting paid by SC&G?
I'm not being paid by anybody.
You mean for your testimony today?
Yeah, for my testimony today.
But you got paid for your work that we're talking about today?
Well, yes. And just as you're being paid for your work today.
And you said that you looked to your client for guidance, didn't you?
Yes. I hope that there was an open line of communication between me and the client would be clear in guiding me when they chose to. I think they were.
And because that's what you told SC&G and Santee Cooper on January 14th, 2016. Right, there was a meeting right before the release of the assessment report.
Okay, thank you for making that a little clearer, because asking me whether I just generally look to my client for guidance is a little open-ended and unclear. I think what you're referring to is that I was getting conflicting direction, and I just wanted definitive guidance from the client. I think that's what you're referring to. I'll assume that, unless you tell me otherwise.
If we look down, up on the screen, we can see it. These are Steve Burns' handwritten notes from that meeting, and we see all the folks who were present, right? From Santee Cooper, Lonnie Cooper, Mike Baxley, Crosby, Pelcher, and Cherry. And you see from SCANA, it was Kevin Marsh. I believe that's Jeff Archie. Steve Byrne, Ron Lindsay, and Al Bynum, and then G. Winnick. That's you, right?
Yes, it is. I assume that it is.
Okay, and then there's the notes. If you go down about most of the way, the third entry down is GW.
Do you have a copy of this handy?
What's that?
Do you have a copy of this document handy?
This is GCJ 9, so it's part of the hearing exhibit. I do not have a copy. Can you enlarge it a little more? All right. I can go up to the second and third. There you go. A little bit below that. So LC there is talking. You can see the The fourth and fifth line down, protecting from litigation perspective is in conflict with original intent. You see that Steve Burns' note about Lonnie Carter's comment? And then the next line, right above where it starts with your entry, protection doesn't mean only GW can see the report. Santee attorney must see. You see that those notes? Do you remember that part of the conversation where Lonnie Carter was directing you to make sure the Santee attorney sees the report?
I see the section of the document you're referring to. I dispute that refers to a direction, because that wasn't the final entry on that page. It was part of a dialogue. And part of the party's efforts to come to a consensus about what to do.
All right. Well, let's look at your response to that comment. I'm just counsel and look for guidance. You see that right by GW?
Yes, thank you. And that really underscores my point that Lonnie said some things, and I don't know how full those notes are of what he said, but he said some things, and I said, fine, I'll just do whatever my client tells me. I'm looking for guidance. Tell me what to do.
Let's go to the next GW entry. See what it says there, and we talked about this in your deposition. If we don't, and that's the sign for delta, meaning change, if we don't change, their prediction will be viewed as owner's opinion, consequences.
I don't know that delta means change. I don't know what, I didn't see these notes until you presented them to me in my deposition. We kind of went around and around on what delta meant, and I didn't think we reached a conclusion. There was never any discussion of changing the report, if by change you mean changing the language. There was discussion about my edits, and my edits never involved changing any of Bechtel's opinions or statements. There were deletions involved. Now, if D stands for deletions, then that may not be an exact quote, but that's consistent with what I wrote way back in 2015 when I recounted the case in the Western District of Pennsylvania, where the consultant, I said, decided the case. Remember that with the quotes? Here, I'm more or less making the same point. If we leave in some of their predictions, those will be viewed as owner's opinion, and Bechtel will have decided the case, again in quotes, because someone in the court proceeding is going to be waving that report around in the courtroom, and you can present all the evidence you want, saying it was preliminary and look at the qualifications, and they didn't have discovery, and they used a bad method. But what everybody's going to remember and look at is that shiny object that the attorney for Westinghouse is going to wave around, and I promise you they would do it. So that's the point I was making, and yeah, have I answered your question?
And then some. Do you think that there's a material difference between changes and edits and deletions?
Well, there is to me. Is it adequate?
I think so.
Yeah,
I can hear you.
The court reporter came to the rescue and suggested a lavalier.
You hear him in the back? Mr. Erskine? You hear him? Okay.
Yeah.
All right. Mr. Winnick, and since we're here and Mr. Jones testified about it, these are the same notes where you can see LC says they don't want Bechtel to whisper in the market that we whitewash the report. You said that you used, of course, the blackout, and we'll look at that in a minute, but is that part of the discussion in this meeting about whitewashing the report by changing it or deleting things from it?
I don't remember that comment. Those notes say what they say.
And so you were taking direction and guidance from SC and G in your representation on the report, weren't you?
That's half true. I was taking guidance from SC&G and Santee Cooper.
So, but at least you were not unilaterally withholding the draft report from Santee Cooper for more than 2 months, were you?
I didn't withhold the draft report from Santee Cooper for any length of time. They didn't. There was no agreement that should be distributed. I don't think it was.
Let's go back to the beginning just to get a little more clarification here. You didn't decide to do the assessment, did you? I made the recommendation in 2014 to bring in somebody to assist me in evaluating legal issues. When I first learned of Bechtel being interviewed, I assumed that was action on my recommendation. So no, I didn't decide, but I assumed that was action on my recommendation. There may have been other motives in mind of the people who brought them in, but I would hope that they were acting on my recommendation. And you didn't decide to use Bechtel for the assessment either, did you?
No, I didn't select them, and probably would not have. But when I learned that it was Bechtel, I thought that was fine.
And you didn't agree to pay $1 million for the assessment, did you?
Actually, I quite literally did in a legally binding document that I signed on behalf of my firm.
But somebody gave you that number, right?
Oh, there's no question.
On the level of payment.
Oh, there's no question about that. I wouldn't have chosen a lump sum payment had I been left to my own devices.
Right, and you didn't decide or even agree on how to make the payment for the assessment, did you? Testify to that.
Actually, no, I did. In my negotiations with Martin Daw, there was some back and forth about payment, in particular the final payment. Do you want me to tell you what I remember of that?
Well, you actually withheld or had SC&G withhold the last $250,000 until that final report was issued, right?
That's collapsing a lot of issues. What happened was that Martin Dahl wrote me an email saying that he understood that the oral presentation would be considered to be the final report and that they wanted to bill immediately. And so I checked on that and wrote him back and said, no, I think I said something to the effect, I've spoken to the client at the highest levels, which means Lonnie and Kevin, and they said, no, they want the report. And so you're not yet eligible for your final payment because you haven't completed the scope of your services. Does that answer your question?
And you didn't decide what the assessment would analyze, did you?
Well, again, the initial proposal by Bechtel had one scope and had certain things excluded, and I modified that. So, I think I had a role in deciding what it was. I wasn't the sole person that decided it, but I had a role, and all of that's reflected in my email, where I question language in Bechtel's original proposal in two separate emails, one in May and one in July of 2015, and then that language is not found in the actual agreement that the parties entered into. So to that extent, I did select what they were going to do.
Based mostly on what the client was giving you guidance on, right?
On that particular issue, I don't remember consulting with the client during my negotiations with John. I made those recommendations immediately upon receiving Al Bynum's May email. And then I repeated those recommendations in July. It's about 6 weeks later, and those recommendations were accepted by the client.
You didn't decide how long the assessment would last or how many people Bechtel would use, did you?
That's true on both counts.
It was already decided before you got involved.
I don't know if it was decided, but I didn't have a role in deciding it.
You knew that Santee Cooper, for example, wanted this assessment of the project by a third-party engineering firm to make the project better, right?
I think that they hoped that the report would serve my needs as counsel while also giving them additional insight to enable them to make the project better. So to that extent, I agree with you.
You knew that the primary purpose of Santee Cooper was the ordinary business reason and not anticipation of litigation.
No, I don't know that. I think that it would have been irresponsible of Santee Cooper to have that as their primary goal while authorizing me to enter into a professional service agreement that says otherwise.
Let's look at Lonnie Carter's notes where he says very cleanly and plainly that this was never, let's read it, assessment is not and never has been intended to position owners for litigation, but we're not going to give up our rights. Was that communicated to you?
No. No, but it's inconsistent with their approval of the agreement. I think Lonnie may have said that from memory and not gone back and reviewed what actually happened.
That's because you made, and SC&G made, signing your services agreement a condition of the project going forward, right? Of the assessment going forward, right?
I don't know how we would have done that. I don't recall anybody expressing that. We're not going to hire Bechtel unless we hire him through Winnick. That was never said to me. It was never said in my presence. Nobody communicated to me that anybody said that. So I can't agree to that.
But you made it your primary purpose, right? To get involved in this.
I made the Bechtel assessment, the primary purpose of the Bechtel assessment to be to assist me in understanding issues on the job and prepare for anticipated litigation against the contractor in the Southern District of New York.
Before you got involved, the same was true as with Santee Cooper, with SC&G, that it wasn't for anticipation of litigation before you got involved, was it?
Al Bynum, I think, I had recommended that we bring in somebody for litigation purposes in 2014. Al Bynum then writes me the letter in May saying, does this sound like a good idea? So it seemed to me it was still in its infancy, this whole idea. And as the idea matured and developed, I influenced that. I would hope that I had that role. And I think I did.
And your purpose actually was not to have, like in this Pennsylvania case, that one case you had in the 80s in Pennsylvania that informed you on this. In that case, the report actually analyzed legal claims, didn't it?
It analyzed present claims for extra work, and that was not done in anticipation of litigation, which is why I was able to force its production, and had a good result for the client, bad result for the opposing party. I didn't want that to happen here.
And here, you actually didn't have Bechtel analyze any legal claims at all, did you?
The principal claim that I was worried about was schedule, and I thought that Bechtel would analyze the Westinghouse schedule, not develop a schedule that they did with the flaws that I believe it had.
And your concern, in part, to make sure it was protected, was the assessment that it might be unfavorable to your client, especially SC&G, who was managing the project.
No, and favorable, I think, is the wrong word choice there. I think damaging to the client. Damaging to the client because if we are litigating a several $100 million claim in the Southern District of New York, and Bechtel produces their report and it's public, and counsel for Westinghouse has it, they are going to claim that liquidated damage provision should not be enforced. They're going to come up with a variety of legal theories to do that. One is breach of the duty of good faith. Contracting parties have an obligation to share information with one another. They will contend that was, despite what it says, they will contend that was a final report, and we should have shared it with them and shouldn't have tried to tie them to dates that were earlier than what Bechtel had identified. They'll claim that we had bad faith, superior knowledge, impossibility, all sorts of legal theories, none of which would have any chance in that proceeding without the Bechtel report. So I thought it would be, it would prejudice the client or had a substantial likelihood of prejudicing the client if we went to litigation with the contractor.
You took care of that, didn't you, in the the August 7th agreement when you got the consortium to agree that Bechtel was a non-testifying expert?
I don't know how that takes care of it. If the report gets out and it's going to be used, and when you're representing two parties that have hundreds, perhaps thousands, probably tens of thousands of employees, reports get out. They do. And I didn't want to be the lawyer who allowed all of those arguments to be made on a $700 million claim because I allowed a report that I thought was really not fully baked to get out. I just didn't want to be that lawyer. So I took steps to avoid that.
Isn't it true that the report itself, right, and you're familiar with that, and the, let's say, Attachment A, which was the scope of work to the personal service agreement, state that the objective of the assessment wasn't for litigation, but to assist the owners to better understand the current status and potential challenges of the project?
Well, you're referring to Exhibit it's Exhibit 111, and
yeah, let's pull that up if you don't mind. The first sentence of
I'm sorry,
the
not 111.
assessment objectives of Attachment A to the PSA, August 7th.
The objective of Bechtel's assessment is to assist SCH and owner in better understanding the current status and potential challenges of the project in anticipation of litigation, and also to help ensure the project is on the most cost-efficient trajectory to completion. So that's what it says.
Right, and everything but in anticipation of litigation had already been part of this discussion among the owners and Bechtel before you ever got involved, wasn't it?
There were clearly discussions between Bechtel and at least Santee Cooper about an assessment that would accomplish some of those things, as you say, anything but, which is pretty important but yeah, anything but in anticipation of litigation. I don't know if Santee Cooper mentioned to Bechtel in any of their preliminary meetings the concept of engaging them in anticipation of litigation. I wasn't involved in those discussions, and I have no idea. As I mentioned, I thought that they engaged Bechtel because of my recommendation that I would benefit from having consultants brought in. That was my first reaction when I heard about Bechtel.
And so, when you took what was already existence on the assessment and added it to paper here, it shows that the agreement, your agreement that was signed, says specifically that the assessment is to assist the owners to help ensure the project is on the most cost-efficient trajectory to completion. That's part of this sentence, isn't it?
Well, it is. I read the whole sentence, so every word that I read was part of the sentence.
And the words that you say make this a sweet-smelling rose is the in anticipation of litigation that you added after the owners and Bechtel had already decided on what their objectives were.
No. On page 1 of the agreement, it says that the communication shall be regarded as confidential and made solely for the purpose of assisting SCH in giving legal advice to the owner. And then I think again on page 2 in paragraph 5, it is agreed that Bechtel is being engaged in anticipation of litigation or other dispute resolution process related to the project, but is not being engaged as a testifying expert. So I think all of those, I'm not going to adopt your metaphor about roses, but I think all of those things indicate what my intent was. And that was never a secret from anybody. I was consistent at every step of the way that was my intent before I reached out to Bechtel, when I reached out to Bechtel, when I entered into an agreement with Bechtel, when I discussed what their product was with the client. That was my view from the get-go and consistently throughout.
There was nothing in the schedule assessment report damaging to the owner's claims against the consortium, was there?
It's helpful to be specific about the claims. The claim that I thought could be undermined by the schedule assessment would be a claim for liquidated damages, as well as a defense to a claim for delay damages, which could also have been in hundreds of millions of dollars. And that schedule report could have undermined both the claim for liquidated damages and the defense to the contractor's claim for delay damages.
And in particular, it's because it would have shown that your client knew that the dates were really much later, and so the delays were not really, couldn't be held against them.
The client didn't know what the dates were. All they had was somebody's projection, and then you have to evaluate the projection. We evaluated it contemporaneously as not justifying a change to the schedule dates. Bechtel agreed. Bechtel agreed that a more robust analysis was needed to do that. Having made that decision, we didn't want to afford the contractor the opportunity of saying otherwise, saying, no, you did know. They would do what you just did. You knew. Well, you didn't know, but you knew. Bechtel, I mean, goodness, big company. They've done nuclear. This must be the truth. You knew this, therefore you can't claim these damages. I didn't want to get involved in that back and forth. And there's no reason that I should. No reason that I should subject the client to that risk. And I didn't.
So the real risk and the real damage of the report, particularly the schedule assessment report, was that it would be disclosed at all. And for example, in this context, call into question them coming to the commission and asking for more revised rates based on a different schedule.
You're wrapping too much into that question for me to follow, let alone agree to. Can you rephrase?
Yeah, I mean, one of the things that the schedule assessment report says, and you keep talking about, and we're going to look at it, this more robust is needed at the time. I mean, what you did was actually prevented at least one of the owners from doing that additional work to see what the real construction schedule was.
I didn't prevent the owners from doing anything.
They chose not to, even though they knew what the schedule assessment report said and recommended.
They knew what Bechtel's schedule projection, guess, whatever you want to call it, said. They knew that because they were in a conference room over at the SCANA campus on October 22nd and received both an oral presentation and a slide presentation. So they knew what the dates were. They knew what Bechtel was saying. The question was, do we put any stock in it?
Okay. Let's look at that October 22nd presentation. You said, I think you testified you didn't even bother to show up in person, even though you were coming to Columbia anyway that day, right?
That's right. I was working on slides for the presentation to the Santee Cooper board concerning the October 2015 amendment. And I judged that to be a more important use of my time.
And you also said you didn't even stay on the call the whole time for that Bechtel presentation, did you?
I didn't dial in when the presentation began, and when they began the scheduled presentation, I interrupted and asked a series of questions about methodology and got the answers that I got, and then I had very little interest in what they were projecting, guessing. You use the word you like, but I was basically done. And then I focused on what was really the important matter at hand, which was getting assent to the October 15 amendment from the Santee Cooper Board.
Well, let's look at your words here in the deposition. I asked the same question. You said, I did, I was done with them. Same answer you just gave, kind of. But you continued saying, I wasn't that interested in them to begin with. I was, on top of the next page, you just go on to say, I was in Columbia that night, and if I'd been interested, I would have flown up in the morning.
Yep.
That was before even seeing any written materials at all from Bechtel, isn't that right?
That is true, because the Bechtel analysis was guaranteed to be obsolete, at least in part, because of the amendment that I was working on. For all the reasons that I'll mention, I'll repeat them if you like.
No, and we'll get to the amendment in a little bit. You actually defined what you meant in the deposition, but not today yet, by unreliable methodology of Bechtel. And given that you formed your opinion before you saw any written materials and without much care, let's look at what you found as the unreliable methodology of Bechtel.
No, I came to the opinion about the unreliable methodology when Bechtel explained to me what the methodology was.
Yeah, and here's what you said about it in the deposition. Yeah. Tell me if I read this correctly. I remember thinking whatever is coming out is going to be useless. Unreliable methodology, not enough time. You said it's preliminary. You said words to the effect, in order to give you any meaningful projections, we have a lot more work. And they said those words, and then...
at the meeting.
Yeah, this is your recounting...
What happened on October 22nd. So that's not why I didn't attend, because I didn't know what they were going to explain to me when I decided not to attend.
I understand.
Okay, I was confused then. So.
No. You didn't attend the meeting. You called in for a little bit of time. You didn't care that much, and you hadn't seen anything in writing. But here's your conclusion about why it's unreliable methodology. Right? This is your explanation of it.
Well, that's part of it, sure. I also explained in my email to Ron Lindsay the whole issue of the level 2 versus level 3 schedules. I also mentioned that they hadn't downloaded the Westinghouse schedule, and I think I put a little more meat on the bones by going through the ultimate report that I got.
And we'll cover all those.
Okay.
But you go on to say that they said those words and that they lay out the number, and then they laid out the numbers. And by that time, you had stopped listening. I may have been on the phone, but I'd stopped listening because I don't care if they say tomorrow, 5 years, or 20 years. It means nothing to me. And then you finish up by saying, if you don't have the reliable methodology, your result is just not useful to a construction litigator, right? For your purposes.
Right.
That was the end of it.
And except it got worse when I got the actual report.
You've testified that the 2015 EPC amendment and the shift to the fixed price option protected SC&G from cost overruns. Is that right?
What I testified to was that by eliminating all 4 categories, but in particular the target price category, that the owner was no longer obligated to pay cost plus for on-site work. Now, if by cost overruns you mean it protected them from any changes or any claims for extras or anything else, I certainly didn't mean to suggest that. So thank you.
And owner's cost too. I mean, obviously that could go up with delays.
All those things could happen, but specifically what I was talking about is that the owner was no longer contractually required to pay cost plus for all of the site work, which was where the owner's exposure was. So it's not quite as broad as you suggested there.
And it's really just a setup, so let's move on. The EPC amendment actually does not protect the project at all, though, from schedule problems, does it?
Well, if by protect you mean does the contractor waive any future claims for delay? No. Are there elements of the deal that do afford some protection to the owner? Well, I would say yes. The elimination of CB&I both removed a contractor who wasn't doing very well and who had bad relationships with Westinghouse and promised to bring in Fluor. So absolute protection, no. Were there mitigation measures that were part of that whole deal, all the chess pieces moving around the board, CB&I gone, Fluor moving in? Yeah, those things were good for the project and did afford some risk reduction for those kinds of schedule issues.
It clearly didn't solve the schedule problems, though, did it?
I don't know any paper that could, but no, it didn't.
And the 2-year delays that this Bechtel schedule assessment determined would have taken the project out of the money because it would have cost over $2 billion in production tax credits. Isn't that right?
My expectation is that those dates, no, it's not right. My expectation is that those dates would be moved. I think Vogel has either already moved those dates or is working to move those dates. I think that Congress would have been sympathetic to moving those dates, and I would have anticipated that those dates would move. In
late 2015, those dates weren't moved, were they?
No, they weren't. They weren't, but it was contemplated that they might, and the agreement actually specifically mentions that. The agreement specifically mentions the possibility that those dates would be moved, those tax credit dates would be moved. You know, it just comes back to my thought that this project wasn't canceled because of delay or cost overruns. It was canceled because Westinghouse went bankrupt.
In fact, in that amendment, when you are contemplating the movement of the production tax credit dates, y'all actually let the consortium off the hook, didn't you? And you extended the time for them to get a bonus if they met them, and so you didn't hold them to the schedule even in that amendment, did you?
No, that's not quite right. So for liquidated damages to be enforceable, I'm going to offer my thinking here. For liquidated damages to be enforceable, they have to be a realistic projection of actual damages. In order to support what could be $900 million in liquidated damages in this agreement, there had to be some factual basis. The costs associated with delay and lost production of electricity and so forth wouldn't support that number legally. But the loss of the tax credits would support that number.
That EPC contract, that amendment, was finalized before the October 22nd call with Bechtel, wasn't it?
It wasn't effective then. I believe it was effective the end of December because I mentioned pieces moving around the chessboard. Westinghouse had to buy the stock. They wanted to bring in Fluor. They had to get Toshiba to agree that their guarantee would not be disturbed by this change in arrangement. There were a lot of parts and pieces that had to be met, and once the agreement is dated the 27th of October, but it's not effective then. There's a defined effective date, which involves, the term is effective time, and it requires the authorization of all the boards of all the relevant parties. So it was signed in October. It says it's an October agreement, but it's not effective until all these boards approve. And just going purely from memory, the SCANA board and the Santee Cooper board pretty promptly approved it. Westinghouse waited until the end of the year.
SC&G and SCANA, and Santee Cooper had fully executed the document by October 27th, but all of the terms and language had been finalized prior to the October 22nd meeting with Bechtel in 2015. Isn't that right?
Well, finalized. It is true that as of October 22nd, the draft of the agreement that the parties had circulated was agreed to in principle, and that draft wasn't changed between that date and the time of the signing, so 5 days later. So yes, that is true.
Thank you. And you were focused on that 2015 EPC amendment much more than the assessment at that time, weren't you?
Yes.
I want to go to that November 12th date, the day you received the final draft report from Bechtel. You had a little bit of a scare, didn't you? That you were traveling, you were in the air, and you sent some emails to Bechtel frantically, making sure they didn't send the draft report to your clients. Isn't that right?
I don't know about frantically, but Martin Daw had told me that he was going to issue the draft. You said draft final. That's an oxymoron. It wasn't final. It was draft.
Final draft.
It wasn't a final draft. It was a final draft is not a draft. It's final. The final wasn't issued until February. The draft was issued October 12th. It says draft on it. So Martin Daw was about to issue that directly to the client, and I wanted it sent directly to me. So I made certain that I communicated that to him, and he was fine with that.
You do acknowledge that Bechtel considered that the final draft subject only to the owner's comments, right?
Yes, and well, the owner, I mean, my comments.
It was final as to Bechtel, and they provided it you as the final subject only to your comments, right?
And now you're using words and being. That's a game I'm not going to play. It said it was a draft. I viewed it as a draft, and I acted on it as though it were a draft. And to me, there's a draft in October and two finals in February. And I think that if we stick to that terminology, we'll avoid confusion.
Yeah, I think Mr. Troutman and Bechtel make it clear. Can you go down to the bottom of this email? It's on the next page. There's another page, I think. Maybe not. Let's just go back to where you were. This is a George Winnick email, Thursday, November 12th. Subject, Martin Sell. See that? This is an email from you to essentially Mr. Dawes' assistant.
Yes, that's the email that I sent when Martin announced he was just going to drop the draft report into an email.
And you were sending this email trying to get him on the cell saying, call me first as soon as you can, because you didn't want the draft report to be sent to your clients, did you?
Exactly.
Okay. So we don't need to go into the other emails of frantically trying to make sure that report wasn't sent to your clients.
I just don't know about the frantic. I'm not typically frantic. I didn't want the draft report sent directly to the client. I was pretty careful about that and pretty specific about that with Mr. Daw.
About, I don't know if this is it, but the November 12th at 4:57 p.m. We use the exclamation point.
I think that, oh.
Yeah, they, Elmo.
I don't think Mr. Erskine heard you. You were away from your mic.
She did, thank you.
Okay, got it. Okay.
All right, stop moving it. That's Thursday at 9 p.m. You say you're confirming, basically confirmation. Y'all connected. And the reason you were appreciative is because of the 2 p.m. email when Martin Dahl finally responded to you saying, I'm in the UK, no final report will be issued until we hear back. Right? That was what you were trying to avoid. And below that, this is the 4:57 p.m. email where you're sending him, please hold the final report. That is extremely important, exclamation point. I've been instructed to receive the draft and review it before it is final. We may decide we do not want a final, call me if you have any questions. Here's my cell. You had previously gotten his cell to try and reach him. I mean, this was important to you, wasn't it? Extremely important to you, wasn't it?
It was. And I'd been instructed to follow my normal procedure, which is to review the draft report before distributing it kind of willy-nilly.
And who gave you that instruction?
The client. And I know you want to know who, but I don't recall.
And after this, you talked with Ron Lindsay and Steve Byrne about what was in the draft report, didn't you?
I have no recollection of that, but it would seem likely that I would.
Seems likely?
Yeah.
Sure. Yeah. But you didn't talk to Santee Cooper about what was in the draft report, did you?
That seems unlikely.
Who would you have spoken with at Santee Cooper?
Well, initially, my contacts on things like that would have been Mike Baxley and Steve Pelcher, because Mike Baxley, of course, was general counsel. Steve Pelcher, I believe, was project counsel. That may not have been his title, but that's how he functioned. He was another lawyer at Santee Cooper. So those are the two that I normally would have talked to in the first instance about matters like this.
Okay. And on November 25th, you sent back to your response to the draft report, right?
The timing seems right.
And your response, as we've talked about, I think, was to use these black boxes to completely obscure large sections of the report, right? Full pages. I mean, the page after page of just total black boxes, right? That's your deletions, I think you called them.
Yeah, I would have preferred to do it in the more traditional way with redlining, but I remembered that I asked Mr. Daw to send me an editable version in Microsoft Word, and what he sent me was a PDF, and so the PDF redaction comes out that way. Had I received a Microsoft Word version, I would have done typical redlining and underlining to indicate deletions.
And all these redactions were intended to remove the entire analysis and discussion and conclusions of Bechtel's schedule assessment, right?
Yeah, I testified to that.
And you also told Bechtel not to send it to the owners, isn't that right?
Not to send the draft to the owners.
Right. And in fact, in your deposition, you claimed that the invitations that you had given to the owners to see the draft report just never came to pass. You remember that?
There was a discussion. What I remember is that there was a discussion of the lawyers, the two that I mentioned, Mr. Baxley and Mr. Pelcher, as well as Ron Lindsay and Al Bynum, to come to Atlanta to review the report. And that didn't come to pass. We, in fact, met sometime later in Columbia.
Well, and you never let Mr. Baxley, right, see the report, did you? Draft report.
No, I didn't distribute the draft report at all.
In fact, Mr. Chairman, we'd like to enter in the next hearing exhibit. It's a voicemail message from Mr. Baxley to Mr. Winnick on December the 3rd, 2015, about seeing the draft report.
We're going to need to hear that before we're going to enter it.
We're working it. We're going to do both.
George, hey, this is Mike Baxley. In follow-up to our discussion.
Start over.
We got to crank that up a little bit.
Test.
Hey, this is Mike Baxley. In follow-up to our discussion a couple of days ago, I appreciate the position, I guess, where you and I both find ourselves a little bit conflicted with maybe different instructions. So Steve Pelcher, Lonnie, Mike Crosby, and I came up with this plan and wanted to see if this was satisfactory to you. Steve and I, so just the two lawyers, would come down to your office in Atlanta one day we just fly in on the early flight, spend the day in your office reviewing that document, the document you have now, the one that's unredacted, not yet changed in any way. And we may take notes, we may have some, observations from it, but we would not ask to leave with a copy. We would simply come, look, and then leave at the end of the day. We suspect, as I recall your description of the length of it, it may take a whole day to do that. What do you think about that? If you are satisfied that that meets everyone's needs, then we'll be glad to get Lonnie to call Kevin and just, get the okay on it. I simply would just say this. We've got a couple of one particularly sophisticated member of board director who's an investment banker, done a bunch of big deals, and he is watching us fairly closely, as he should be, and not in a critical way, but just I want to be able to tell him at some point in the future if things don't go as well as we'd like. We did everything. We looked. We understood. We saw. And I would feel much more comfortable we could do this. Thank you, George. My cell, 843-49.
Thank you, Mr. Chairman. Mr. Winnick, do you remember receiving that voicemail message?
I do.
You want to enter that?
We will, yes,
Okay.
sir. Would you go ahead and mark it, and we'll provide the audio file?
121.
Thank you. Also, Mr. Chairman, I was reminded that y'all don't yet have the November 25th heavily redacted version of the draft schedule, draft report, and we'd like to make that a hearing exhibit as well.
That will be Exhibit 122.
Because of the heavy blacklining, I think we only printed about 3 or 4 copies, but everyone, except maybe Mr. Guile out here, has it.
I love the blacked out parts, especially, Mr. Chairman. Yeah. I can black out the remaining parts and give it all to Mr. Guile if you prefer. That's what I need for a night's sleep tonight, thank you.
Oh, there you go. Okay.
Thank you, Mr. Chairman. And Mr. Winnick, do you remember that Judge Baxley calls again the next day on December the 4th wanting to know essentially how you were going to redact the draft report, which you had already done with Bechtel 10 days earlier, but not shared with him? Do you remember that?
I don't remember that, but I don't remember anything inconsistent with that.
All right, let's listen to it.
George, this is Mike actually calling in follow-up to our discussion earlier today so that I can fully advise our team, our business team, executive team here about how we need to respond on this document we've been discussing back and forth. Can you call me, and Monday will be fine. We have a board meeting Monday morning, but we should be finished by midday or early afternoon. And tell me what I guess would be the thresholds or the criteria that you're going to use in determining what is relevant to the report and should be included and what should be removed. If you can give me some subject matter with some level of specificity, I think it will help our team while we're considering which way to go based on the way that you believe this needs to be done. So, again, Monday would be fine. In the meantime, you have a good weekend, a great Christmas event for your party, your bar, your firm, and I look forward to talking with you soon. Goodbye.
Mr. Chairman, we'd like to make that the next hearing exhibit, and we'll submit the audio file.
Be entered as number 123.
Do you remember that now that you've heard it again?
Well, I now that I've heard it, I remember talking to him that morning, as he mentioned in his email, because I called him back when I got the message from the prior day, and I remember him asking about the criteria. I didn't put it in chronology, but I do remember the issue.
What he's really asking is he if you're not going to let him see the unredacted draft, then how are you going to determine what you're going to take out?
No, that's not what he's asking. He's not asking if you're not going to let him see the unredacted draft, because I didn't tell him that. He proposed a attorney meeting. You heard in the first voicemail that he proposed that he and Steve Pelcher would come down. The way I remember it is that evolved, and it was going to be the 4 lawyers that I mentioned earlier, and they were going to come to Atlanta, and that was perfectly fine with me. And then that didn't happen. It's Christmas season. It didn't happen, and we instead agreed to meet in Columbia a couple of weeks after the New Year.
I think we're back to the way you were dealing with this client on this issue about waiting to seek consensus instead of just doing what one of the clients was asking you to do.
Well, Mike is actually on those emails, or those voicemails rather, and in person is very polite, and he understood the bind that I was in. He said that he felt he was in between, and I told him I felt like I was in between because the clients weren't in agreement as to the process, and so I wanted the clients to be in agreement. I had understood that above Mr. Baxley's level was Lonnie Carter, and he and Kevin were trying to come to consensus on precisely what to do, which we did come to.
You think Judge Baxley was acting contrary to what Lonnie Carter?
I didn't say contrary. I would say that he was acting. My belief at the time was that he was acting on his own and not at the direction of Mr. Carter. I didn't know if he was. I certainly wouldn't say he was acting contrary to Carter, but where the parties weren't in agreement, I wasn't going to just listen to Mike unless he said, do it. I mean, if he had given me a clear direction. But we're all trying to be courteous and thoughtful and polite to one another, and things dragged on until we all got consensus.
He's offering to come down to your office with Mr. Pelcher, so he's clearly not acting alone. And the way that you put it about being in between them having different opinions was that SC&G didn't want him to see it. Isn't that right?
SC&G was taking my recommendation that the draft should simply come to me, that I would make my changes, and then the document would go to the client or not to go to the client. And I was perfectly happy to have him come to Atlanta. That's obviously very convenient for me. And that was fine with me. As I say, we were talking about the 4 lawyers coming down. The meeting didn't take place.
But you weren't fine with it being over the objection of SC&G, were you?
The way you're putting it is that there was an objection. To me, there was not consensus. To the parties, there was not consensus, and they were trying to get consensus.
All right, let's go at it a little bit different way. I mean, you weren't refusing to show them the draft report because, including your client's own in-house counsel, because you were claiming it was attorney-client privilege, were you?
No.
And so it was another reason, or an instruction from SC&G, right?
No. It was my own judgment about the best way to handle that document, and I didn't have direction from the client as to what to do. But when he proposed coming down, I was fine with that. What I didn't want is this report that I thought would be damaging in eventual litigation, if we got there, to be sent out in email form, then goes to a variety of other people, subject to open records, subject to all these other things, people shipping the document off to third parties, which I gather that's eventually what happened some years later. I didn't want that to happen.
This wasn't a formula for Coca-Cola, was it?
If you mean by a trade secret, no, it's not. It's not a patent. It's not a trade secret. But was it confidential information? Yes, it was. Was I going to do all the things that I felt I needed to be consistent with maintaining the confidentiality of that document? Yeah, I was.
I mean, this was an assessment that of the project that they had been asking to be done for a year, and when it was finally done, it's been being hidden from them after you and Mr. Byrne knew what was in it.
No.
Oh.
No.
And then, SC&G does the same thing with the schedule assessment report, right? From the commission, ORS, and the ratepayers, even well into this litigation. The same, they follow the same playbook.
No.
You're just not willing to admit it.
Well, I'm here under oath to giving you my best answers and trying to testify truthfully. And my answer to that is that most of what you said has nothing to do with what we were doing in December of 2015 and February 2016.
And in fact, to be fair, I mean, you never instructed anyone at SC&G not to disclose either of the reports to ORS or the PSC, did you?
No, I didn't.
It was actually SC&G's decision not to disclose it to commission.
Right. I didn't make that decision. I don't know the ins and outs of the decision-making process once the draft left my office sometime in February.
And, you know, we've taken the position that this assessment was never about legal advice to the owner, but you can confirm for us that this assessment was certainly never used by you to give any legal advice, was it?
That's never used to give legal advice. No, I think that's a bridge too far. There are certain things that I learned about the project. I mentioned one of them related to procurement, and in particular inventory control, that I remember discussing with the client and making certain suggestions to them about how to address that issue. I've said earlier that they knew about some of those issues, maybe they didn't know about all of them. So to say that I never used it to give legal advice, I think that's a stretch. I certainly didn't use it in any anticipated litigation because no litigation transpired.
Right, and we've already seen on October 27th what your view of the assessment, even before you saw it, was that you just didn't care. I mean, that's really what I was getting at. Is that not only, right? Did you not use it in any litigation, but you didn't use it to give them any legal advice on any negotiations or matters either.
Well, no, that's not true either. First of all, you said on October 27 when I hadn't yet seen it. On October 22nd, I'd heard it. Granted, I didn't see the slides, but I called in for that part. So I heard that part, and I heard their responses to my questions. The legal advice I gave them was that I did not consider that to be a worthwhile evaluation such that we needed to rebaseline the schedule and advise Westinghouse of that and disrupt the October 2015 agreement, which had certain dates in. I gave them legal advice on those issues. So I think I did give them legal advice. And the legal advice is don't use that document.
You admitted that SC&G paid Bechtel directly for the assessment, right?
Yes, that's customary.
But it's contrary to your services agreement, isn't it? In paragraph 2, where it said the fee will be paid by SCH, isn't that the acronym for your law firm?
Yes, that's the way it's set up.
Right. And so you and your clients didn't follow all the terms of this agreement, did you?
Well, if by paid, I don't think they cared if I caused them to be paid by the client or whether I paid them directly. I think that I satisfied the agreement. The owner was not a party to the agreement. So Bechtel would have been in an odd position agreeing to do $1 million worth of work with me, but agreeing that some third party who's not a party to the agreement is going to pay them. So the agreement was that my firm would pay them. If the owner had disappeared or welched or fired me and decided they weren't going to honor it, we were on the hook for it. That was a legally binding obligation. I had to discuss that with my partners before entering into it, by the way. That's how law firms work. But as it happened, the client paid directly, and that's customary. The bills went to me, though. They came to me, I reviewed them, I approved them, sent them on to the client, and the client paid directly.
I mean, it was a little bit of a contorted agreement. I mean, you even admitting that even before you signed this agreement that you weren't going to follow it according to its terms, right? It wasn't going to be paid by SCH. Even before it was signed, you knew that.
I don't think that it's a fair characterization that we knew we weren't going to follow the agreement when we signed it. It is accurate that I anticipated that the client would pay directly. To me, if I commit my law firm to paying $1 million and the Bechtel commits to provide services for $1 million, and I arrange for the client to satisfy that debt, that I've complied with all of my obligations concerning payment. And it's not the first time I've done that. I routinely do it. These consultant bills can be quite expensive, running into $4 and $5 million. And frankly, we've had some successes at the law firm, but we don't like to make disbursements of that size directly. So when we can get a client to do it directly, we do. We normally receive the bills, vet the bills, forward them to the client pays directly.
Oh, and I don't think there's any problem with that, other than it puts into context, the agreement that you had, that you signed with Bechtel. But after hiring Bechtel through this agreement, and until the 22nd of October, you didn't have any other contact or communication with Bechtel, did you?
No, I often don't. Normally, I understand what the consultant's going to do. They're sign the agreement. They go off and do what they do. They then provide me with their draft report, and I make their comments, and that's often when I first learned about it. I can tell you that's exactly what happened with my scheduled consultant in this case that I just finished.
So your primary purpose was to protect the document. You got it done on August the 6th or 7th, and then the next time that you interacted with Bechtel, supposedly your expert here, was at that not showing up but calling in and on the October 22nd.
Yes.
In that presentation on page 25, y'all, Mr. Balzer pointed out, and you've continued to use this statement about more being needed prior to finalization of changes. Let's look at that sentence again. I think it's the last one in that section. Right there. Is that? Yeah, right there.
Right.
Can you blow it up a little bit bigger? A more robust approach is needed prior to finalization of any changes to the baseline target schedule. Now, you've used that as a criticism of Bechtel's schedule assessment, but let's look at it a little more closely.
Okay, but let me respond to that. I didn't use it as a criticism. I used it to point out that Bechtel was aware that their approach was not sufficiently robust and that they would need at least a level 3 schedule in order to make those changes to the baseline targets.
Didn't say that.
No, but that's my interpretation of it.
Well, let's look at what it actually says, because this is a recommendation. I mean, that's you're describing like a backhanded compliment, right? I mean, it's a criticism or a backhanded compliment. But let's see what it actually says, because
Objection, argumentative.
I'm being argumentative.
Sustained.
Thank you.
Thank you for the admission.
This is a recommendation, right, from Bechtel to SCNG and to Santee Cooper. It's saying a more robust approach is needed. Is needed. That's an affirmative statement, right? You need a more robust approach prior to finalization of any changes to the baseline target. Isn't a fair reading of that is saying we've done our part. We've done a schedule assessment. We're not constructing the project on a level 3 schedule, but we've done our part. And prior to finalizing any changes, doesn't that imply that there are changes to be made?
Well, the commission has the language in front of them. My interpretation is that Bechtel was saying that they would need a more robust approach before there was any finalization to changes to the baseline. And robust, obviously, is a metaphor there. And I understood the metaphor to be related to a different methodology and a more detailed schedule, namely a level 3 schedule and a methodology that did more than simply took these bulk commodities and tried to put those into a chart. That's I think Bechtel. I would hope that Bechtel would recognize that I would think that they would say that's what they meant by a more robust approach. That they would go to a level 3 schedule analysis that would dive into the details of the project and not rely on their estimates from other projects, not rely on these bulk commodities. So to me, that's not a criticism of them for this comment. I point to this comment because this is just one more piece of the puzzle. I think I've addressed all the other pieces multiple times, but this is one more piece of the puzzle that led me to conclude that the Bechtel dates were not reliable.
Well, let's look at the puzzle that it actually goes to. It's a fact, isn't it, that SC&G knew on October 22nd, 2015, that Bechtel had made this recommendation to them. Isn't that true?
It's certainly true that SC&G and Santee Cooper were in the room. I have every reason to believe that the slides that Bechtel sent me in January of the following year are the slides that they actually used. So I assume that everybody in that room from the two owner parties, saw all of this and understood it.
And it's not a question of changing the baseline target schedule, but what else was needed for the precise date instead of these ranges to finalize the change. Isn't that right?
I don't know if that's right. I think that a more robust approach might have given you quite different dates, and certainly would have eliminated this plus or minus 8 months, which is what they gave us for Unit 2, and plus or minus 12 months for Unit 3. That's not really, that's a pretty wide confidence band. And I would say that that a more robust approach should narrow or eliminate that band, and it might move it earlier.
And Bechtel is recommending that SC&G do that before they finalize the changes needed on the target schedule, right?
You read it as a recommendation, I don't. So let's just agree to disagree.
And in the EPC contract, actually, that had literally just been finalized, right? And that was about to be executed.
The amendment.
The amended contract. SC&G had already agreed to change the substantial completion dates before it even saw this Bechtel assessment, didn't it?
The draft dates in the draft document were agreed to, yes.
And SC&G had just modified the substantial completion dates in this commission in 2015 to get more revised rates, hadn't they?
I don't remember that. I assumed that the revised dates came in 2016 because the agreement wasn't signed until October. But again, I wasn't monitoring the SC&G's activities before this commission.
Yeah, there were September orders both on modifying the schedule and on revised rates in 2015. You weren't aware of that?
No, as I say, I wasn't monitoring the activity in front of this commission. I was occasionally asked to contribute a review discussion of the agreement because the client looked to me as the person who had the most comprehensive understanding of that agreement.
And you didn't spend any time or do any additional work to figure out what would need to be done to finalize changes to the baseline target schedule, did you?
No.
And you basically just advised your client, SC&G, and supported their direction to you, one or the other, to just bury this material, finding, and recommendation.
I didn't consider this to be material. I didn't consider this to be a finding, and frankly, I didn't consider it to be a recommendation. I considered this to be what it says it is, a schedule assessment. And so I've got Bechtel with all the complaints that I have about its methodology and conclusions, and I've got the contractor who is signing up for enormous potential damages based upon an actual live schedule that they've been building the project by, and I decided that the contractor who had a great deal of risk associated with their commitment was more reliable than Bechtel because of all the issues I've explained. And that's it in a nutshell.
And I'm assuming it is because you're not familiar with the Public Service Commission and this side of the project that you testify that adjustments to the substantial completion dates 18 to 36 months beyond what was just approved by the commission isn't material. Is that right?
No, I didn't. If there had to be adjustments to the schedule, that would surely be material. What I was pointing out was that I didn't agree that this report by Bechtel was material because of all the flaws that I felt were in the methodology and conclusions.
Mr. Richardson, hang on one second, everybody. I'm just trying to manage time here, I'm not trying to cut you off. I'm just
happy to take a quick break and let me reevaluate it.
okay.
On the fly.
Let's take a very quick break, about 5 minutes, because we're running on time here.